to International Trade Law class. Today, we will discuss about the International Trade Agreement in Indonesia. The output of this study is students can understand about international trade agreement in general, and also student has knowledge about how is Indonesia regulate international trade agreement. This lecture would be divided into 3 parts. First, international trade agreement as treaty. Second, the international trade agreement in Indonesia. Third, international trade agreement under World Trade Organization framework and the Asean framework. Now we are moving to the first part, international trade agreement as treaty. In international trade law, we are familiar with the terminology international trade agreement rather than we use international trade treaties. However, some practice may be used a different terminology. As we know, there are numbers of the terminology for treaty, namely conventions, charter, protocol, agreement, etc. International trade agreement here is a treaty made between states and governed by international law. This is also 2 points that stipulated on the Vienna Conventions on the Law of Treaties, 1969. Vienna Conventions on the Law of Treaties, 1969, give the definitions of treaty: an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument, in 2 or more related instruments, and whatever its particular destinations. From this definition, we understand that treaty is an instrument made between states, written form, governed by international law. International trade agreement is an instrument in written form regulate about how the international trade activities between states would be conducted. And about the states, in the international trade agreement, we could also classify the agreement based on how many the states bound to the treaty, such as first, bilateral agreement is an agreement or treaty between 2 states. Second, multilateral agreement is an agreement concluded by many states without any considerations such as region. And regional agreement is an agreement between more than 2 states in one region. After this lecture, the student could identify and please give the example of each agreement. What about Indonesian law? Indonesian law, or our national law, give the definitions about treaty on the Article 1, Law number 24, year 2000. I read in bahasa. Perjanjian internasional adalah perjanjian dalam bentuk dan nama tertentu yang diatur dalam hukum internasional yang dibuat secara tertulis serta menimbulkan hak dan kewajiban di bidang hukum publik. Comparing between these 2 definitions between the Vienna Conventions on the Law of Treaties 1969 and the Law number 24 year 2000, the difference is Indonesian law emphasizes that the treaty governs rights and obligations in a public law. From this definition, we understand that the international trade agreement is when the instrument meet with all the requirements based on the Vienna Conventions on the Law of Treaties 1969 and the Law number 24 year 2000, it should be deemed as an international trade agreement or treaty. We could identify if there's another instrument not made between states and not govern about the public law such as the commercial transactions, we should identify this instrument is not a treaty. Perhaps this instrument is a contract. Now we are moving to the next topic from this lecture, International Trade Agreement in Indonesia. As we know that the International Trade Agreement has an important role for the economic development, since all the states doing trade activities to fulfill their needs. However, every state has different resources, and this is one of the reasons why state needs international trade. Based on this reason, state do numbers of the negotiations with the other states to support their international trade activities. It could be bilateral or multilateral as a member states of international organizations. On 2014, Indonesia has new law for trade. Law number 7, year 2014, is a new law for Indonesia which regulate trade in Indonesia. The questions: to what extent this law govern international trade law or international trade agreement? This law is silent about the definitions of international trade law or international trade agreement. In this law, the terminology that relate to the international trade, there are perdagangan luar negeri and also the international cooperations for trade. The definitions of the international trade is the trade include export and or import activities for goods or services to the other countries. And for the international cooperation for trade, this law regulates that Indonesia, to improve market access and to protect and secure national interests, the government could arrange the international cooperation with the other states or international organizations. Further, the International Trade Agreement, as a part of the international cooperation, based on the Article 82.2 Law number 7, year 2014, that the international cooperation would be conducted based on the International Trade Agreement. This law also regulates about how the government could establish a special team as a negotiator of international trade agreement, and every step in international trade agreement would be discussed and consulted between government and House of Representatives. In terms of contributions from the House of Representatives, this law specifically on Article 84.3 Law number 7, year 2014, stipulated that for the law which will give specific impact and fundamental for the people of Indonesia and also relate to the financial of state and or should follow with amendment or establishment of new law, for this kind instrument should be ratified by law, or we understand as undang-undang. And for the international trade agreement, which not give specific impact, the ratification could be by the presidential regulations, or we understand as the peraturan presiden. This process should be conducted in 60 days, and in the cases that the international trade agreement will harmful for our national interests, the House of Representatives could review the approval of international trade agreement as stipulated on Article 84.6 Law number 7, year 2014. Furthermore, Article 85 also governs that the House of Representatives could review and revoke the international trade agreement if would be harmful for the national interest. If in Law Number 7, 2014, we could not find the definitions of the International Trade Agreement, on the Presidential Regulation Number 82, year 2017, about the negotiator of international trade agreement, on the Article 1, address the definitions of international trade agreement. The international trade agreement is an agreement with a specific form and name in written form to improve market access and to protect and secure the national interests. Based on this definition, the specific character of international trade agreement is to improve market access and should be in written form. This definition is also important to use in the negotiation process, that the international trade agreement is to protect and secure the national interests. In the Article 2 of this presidential regulation stated that the international trade agreement is an agreement made between state, international organizations, or other subject of international law under the Indonesian law. Now we are continue to the third part of this lecture. We will talk about the international trade agreement under the WTO framework and the ASEAN framework. In regards with the purposes of the international trade law as one of the subject in Faculty of Law, Universitas Padjadjaran, we talk about the international trade agreement. It would be the international trade agreement under the World Trade Organizations and the ASEAN framework. Indonesia is the WTO member state since 1994 by Law Number 7, year 1994, as a ratification on the agreement of establishing of World Trade Organization, or we understand or we familiar with the Marrakesh Agreement. This agreement is an agreement between state and government about how the international trade activities under the World Trade Organization would be conducted based on the principles of non-discrimination and transparency. The purpose of this agreement is to reduce the international trade barriers, tariff and non-tariff barrier. As an international obligation for Indonesia, after we ratify the Marrakesh Agreement, Indonesia should comply to all international trade agreements under the WTO, such as for goods, services, intellectual property right, and investment, as well as the dispute settlement understanding as a legal basis for dispute settlement body or DSB. What about the ASEAN framework? ASEAN was established since 1967. However, on the 2007, ASEAN has a legal personality as an international organization based on the ASEAN Charter, and Indonesia has ratified this charter by Law Number 38, year 2008. This charter is very important for all ASEAN member states, especially for the step of the economic integration and in the purposes of the ASEAN Economic Community. Further, there are numbers of the agreement established by ASEAN, and we need to identify does all the agreement fulfill the requirement as the international trade agreement. That's all the lecture for today about the international trade law and Indonesia. Hopefully all the students enjoy these sessions and get more information about international trade agreement, especially under the Indonesian law. Thank you for your attention and see you next time.